special guest. His name is Ron Fatoullah. Ron and Judicial have gone back many, many years, and Ron and I were just chatting. We got Ron from Peter Brogan. Those of you who've known us for a long time, Peter Brogan passed away in 2015, and he was a big part of Judicial Title's growth. And Ron was a personal friend and went to law school with Peter. So welcome, Ron. Ron's going to do a CLE on trust in protecting the family home. Ron is, professionally, he's done as many CLEs for us. It's very easy. And I was just speaking to our IT person, Dan. Ron, he said you were very easy to deal with, very professional, very, very nice and pleasant.
I'll get you next time.
Again, thank you, Ron. And Ron, you're under a little pressure. I think we have over 450, Diana, last I saw.
We have 350 on right now. So,
Ron, the numbers are coming up. So thank you, Ron. Today we're offering 1 CLE credit, and this is part of our monthly CLEs. We do these every month, and our next CLE will be on April 27th. And I believe Dale Robin Siegel will be doing it about mortgages, which is becoming a hot topic in itself right now. Speaking of hot topics, a lot of people are asking questions about remote notarization. In fact, Ron, I think that's going to come right into your bailiwick too, the remote notarization issues because of wills and trusts and everything being signed. Right now, our underwriters are not allowing us to do anything remotely notarized. The barrier is very hard. First of all, we have to record it and keep it for 10 years, which isn't that difficult. Then the notary has to have a journal and journalize everything that happened at the signing of it. And the notary has to keep the journal for 5 years after they stop becoming a notary. I don't know, Ron, is that part of your estate's question here too? Does people leave their journal in their will? We'll have to discuss that. There's also identity proofing has to be done, which is pretty nice. These companies do it. You hold up a driver's license or possibly a passport. Within 10 seconds, 15 seconds, they say it's valid. And then they have to give you what they call a credential analysis, meaning that they do a whole web search of you and they ask you 5 questions and you have to get 4 of the 5 right. And if you don't, then the notary is kind of off. So the underwriters are trying to get this to work. Right now, it's becoming a little difficult to work, but I feel in the next few weeks, few months, maybe, underwriters move a little slower than most. It will be there. But just to clarify, we have both Ron Remote Online Notary and RIN Remote Ink Notary effective immediately. It is effective now. And unlike the governor's orders before, the person, the signer could be any place in the world, not just in New York. They could be, in Europe, and as long as the transaction has something to do with the United States. But again, I think, I don't know if Ron, you're going to go through this, but I think it's going to help you in the long run and with the estates and everything, and hopefully in title insurance, it helps us all. So without further ado, I'm going to introduce Ron. Ron, next 55 minutes is all yours. Good luck, Ron.
Great. Awesome. Great. Thank you so much. And yeah, same here, Rich. And Richard said it all as far as what we know about the remote notarization now. It's so interesting. The individual who signs could be anywhere in the world, but the notary's got to be in New York State. So very interesting. There is a great New York Law Journal article on this. So I urge you guys to take a look. All right, so here's my contact information if anybody would like it. So I am going to focus on Medicaid trusts and Medicaid, but I am going to get into different types of trusts with regard to the home. And we're going to get into life estates and the difference and the advantages, disadvantages, and when you don't use a trust, for the home, to protect the home vis-a-vis Medicaid. I'm going to talk a little bit about estate taxes as well. And I would, as I advise my clients, I think you should advise your clients, you want to get your team together. It's the attorney, the estate planning attorney, elder law attorney, We're going to draft the documents, get the Medicaid plan, get the estate plan together. But that's not enough. You need the financial advisor, the individual who's going to be managing those assets in the trust. It may be the home, not much to manage. What about the other assets in that trust? And I would say about 2 or 3 times a month, we get someone coming in with a trust drafted by another attorney. And sometimes the attorney didn't do the trust the right way, but more often it's the financial advisor who made a mistake, with regard to the Medicaid trust. And we're going to get to that to make sure you guys never, and you advise the financial advisor, never, ever, ever make that mistake. We're going to get to that pretty soon. You want the CPA, and if your client has a care need, a geriatric care manager. Number one, you may want that individual to assess the right level of care. So when we do the Medicaid application, was it going to be for home care, nursing home care? Radically different type of application. Sometimes you want a GCM to come in and do an assessment. Now, we have someone, on our team here that does that. Now, what are the 5 most important elder law and estate planning documents? Of course, it's the will, the planning power of attorney, how that interfaces with the trust. We'll go over, but I gave you an example here. You could give the right to the agent to exercise the power of appointment in the trust. So it all flows together. The healthcare proxy gives someone else the right to make healthcare decisions. Living will, what those healthcare decisions are, and the living trust. So I have about 50 some odd slides. I'm going to be zipping through. I would urge you to listen to my voice. Don't really focus on the slides all that much, because you have the slides, so you don't have to worry about them. So you don't need a trust to get assets to the beneficiaries you want. You could have beneficiary designations, like on a retirement account, or any account. You could have a last will and testament. The issue with the last will and testament is that the document has to be probated, obviously, before the assets can be distributed. And you don't need me to tell you who the parties are to the will, the testator, the executor, the beneficiaries, etc. But just so you know, I'm going to be repeating this a couple of times. When there is an asset that is probated, Medicaid is obligated, it's mandatory to recover against that asset. So a will works, but it may not be the best way to go at all for Medicaid, and who wants to have the client go through probate. So I'm going to talk about the power of attorney just for a couple of minutes, not long term, but you want to make sure that you have an expanded power of attorney, not just the form. You really want to make lots of additions to the modification section of that power of attorney, such as, of course, you get the right to write checks, etc. But what about the right to create, modify, and revoke trusts? We're talking about trust today. What if there's a different type of trust that we don't even know about today, and the individual becomes incapacitated in 20 years? You want to leave yourself flexibility. You want the right to do Medicaid planning, the right, if the client agrees, the principal agrees, to make gifts, to do estate planning, to make tax elections, to disclaim assets, to protect the family home, maybe transfer that home or a different home that the individual buys into the trust that we might have drafted today. So the list goes on. And for Medicaid, we put in an intent to return home. Might protect the home in many cases, if it's not in that trust. So the power of attorney is really a very powerful document. Now, again, I can't emphasize enough, the statutory form is not enough to do most of the things I said. But you might say, well, why are we talking about powers of attorneys when we're dealing with trusts? Is it just that one provision? Well, that's a very important one. Think of the situation where the principal is incapacitated and the trust says that the assets are to go to A and B, and child C, is in prison and he's a drug addict or whatever. Let your mind wander. What happened to child C? But it's not prudent for that individual to get assets outright. So, we could use the power of appointment provision that we typically put in all of our trusts, the right for the grantor to appoint. It's a limited power of appointment to appoint, maybe to his or her descendants, etc. If it's a Medicaid trust, we can't do a general power of appointment. Medicaid won't like that, that's for sure, but you make it limited, let's say to your descendants, and maybe you need a change later on. And if the grantor does not have capacity, then the agent on the power of attorney can step into the grantor's, in the individual's shoes, and exercise the power of appointment. And we could do the best trust in the world today. We transfer the home into the trust today, let's say for Medicaid purposes. We transfer the brokerage house, a brokerage account into the trust, etc. Everything is great. And the client, accumulates more assets that he forgets to transfer into the trust or just doesn't do it. And at a point in time, he or she does not have capacity. But maybe it's prudent, maybe it won't be prudent to transfer into the trust into the future, but at least we have the ability, without going to court and getting, going for a guardianship action, you have the ability to have the agent do this. And that's amazing flexibility that you have to make sure that you have if the client feels comfortable with it. Just a few seconds on the new power of attorney law effective June 13th. Prior POAs drafted correctly that have all of the provisions that you really need, well, those are still good as long as they're drafted right and have everything you need in them. Usually the ones I see don't have everything that I think is optimal, but if everything is in place, it will be good now or anytime after June 13th, 2021. Reforms were needed because it was kind of complicated. We had a statutory gifts rider, separate document that needed to be signed in a different way, etc. It was sort of unwieldy. Banks many times simply refused to accept a statutory POA, and the GOL says, the bank had to, but they didn't. And if they didn't, there was no teeth. So we'd have to bring an action to make the bank accept the power of attorney. And after all of this, what happens? The bank says, okay, we'll accept it, but we can't do much. Now we can. There are damages and yay, attorney's fees. So we don't have the statutory gifts rider. We didn't have that. We don't have now that awful provision that said that the language, the statutory language had to be exact. You had to have exact wording. So technically, if there is a minor error in the statutory language, that would make that power of attorney not statutory. That would not be good. The signing requirements have changed, the acceptance and reliance has changed, and I'm very pleased to say you get damages and attorney's fees. And we haven't had one that we had to litigate, but I would love love, love, love to litigate one of these cases, but I think banks know about it. And, thank God we don't have to. It makes it easier for our clients. So here, no statutory gifts rider, no SGR anymore. But don't forget, all of those extra provisions that we put into the statutory gifts rider now has to go into the modification section of the power of attorney. So make sure that all of the language that you had in the SGR, you bring over into the power of attorney. I want to note that if you name two agents to act, but don't specify if they act together or separately, they must act together. And that could be unwieldy in and of itself. The signing requirements are that you only need two witnesses and a notary, but one of the witnesses can be the notary. The principal or the potential recipient of a gift cannot serve as a witness, and a principal who has capacity but not the physical ability to sign the power of attorney can direct a third party to sign the power. And this is what I really, really love. This is the teeth to the power of attorney, finally. So this is what happens. If a power of attorney is presented to a bank and a bank says, no, we're not going to accept this power, that bank, that financial institution has 10 days to either honor the power or reject it. But the rejection has to be in writing. And that writing goes to the principal and the agent. Now, there's no deadline to, for the proponent to respond. So we don't have to respond in any time frame. But once we do respond in writing, the bank or financial institution only have 7 more days. So we would respond and say, hey, look, bank, this is a good power. The principal signed it. The principal had capacity. The principal is still living. The principal has not revoked the power, et cetera, et cetera. And if the bank still rejects it, they have 7 days to accept or reject. And if they reject it, then we roll up our sleeves. We could sue them and get attorney's fees if we are successful. Now, they can reject the power if they have a reasonable cause to reject it. But absent reasonable cause, they can't do that. And that could be litigated. But I must say, the banks are doing pretty well at the moment. So I'm pleased about that. Okay, so let me just go through some trust basics. I'm going to try to finish by, about 10 to maybe 5 to. I have a ton of slides, but we're going to go pretty quickly. For those of you that fell asleep during trusts in law school, a trust is an entity that's created by an agreement. And that is an agreement between certain individuals, the grantor, the trustee, that have to come together and sign that agreement. A testamentary trust is a trust that's in a will, and a living trust is a trust that's signed while the individual is living, and it's good and valid right now. You don't have to wait till the will is probated. We have revocable and irrevocable trusts. Revocable trust is a trust that can be revoked and amended any time, and it always uses your Social Security number. An irrevocable trust is a trust that's more difficult to revoke, and we'll get into that. How is the living trust funded? Well, according to law now, according to the EPTL, you actually have to change title of the home, the deed, and title it in the name of the trustee of the trust. Same thing with a bank account. Same thing with a brokerage account. Same thing with a life insurance policy where the ownership is changed. How about personal property? How about jewelry? Well, you can assign personal property and jewelry with as much specificity as you can and transfer that into the trust. When is that trust terminated? Well, depends on what the trust says. Depends on the contingency in the trust. It might be for a term of 10 years, or it might be upon death, or, whenever it's revoked. Again, the parties to the trust would be the creator. That's a term of art in the EPDL, or the settlor, or the grantor. So the creator, settlor, or grantor creates the trust, typically funds the trust. Who manages the trust? It would be the trustee of the trust. Can that trustee be the grantor? Yes. In a revocable trust, it's almost always the grantor, but it doesn't have to be. In our Medicaid trust, it's hardly ever the grantor because that's not great practice. And it depends on the circumstances. So you have the grantor, the trustee or trustees, you could have co-trustees, and the beneficiaries. Now, as far as the beneficiaries, you could have lifetime beneficiaries, for example, individuals receiving income or funds during their lifetime or a term of years, or remainder men, or I should say, so we said in law school, or remainder persons who are beneficiaries who get, for example, upon death of the grantor. Is a trust always necessary? No. But if a client, it depends. The client has $150,000 and wants to do Medicaid planning, a trust might be necessary to do Medicaid planning. If a client has $50,000 or maybe $100,000, probably a trust is simply not necessary. Should an attorney draft the trust agreement? Because many clients say, well, I could do that. Let me tell you, maybe they can, and maybe they can get it right, but they need us. They need us. And it's amazing. I've been practicing about 40 years plus, actually. I can't believe it. But every Monday, we have an attorneys meeting in my firm, and we take anywhere from an hour to 2 hours, and we go over cases in our office. Many cases are plain vanilla, and a lot of cases, most cases, we want to be a little more creative. And we have 7 attorneys that we don't bill out for a couple of hours. Yes, I might be a little nutty, but we're there. We go over the problem cases, the cases that might be a little off kilter, and even some plain vanilla cases where we want to have an edge and be a little bit more creative. And we are, but it takes a village. And for a client to say, oh, we're just going to do this. I saw something on LegalZoom. I mean, it's ridiculous. It may look simple to them, but that it's not. And every trust is different, even if the language could be the same. Everyone's circumstance is different. It's a little tweak here, a little tweak there, few words are missing, and that could mean the end of the reason for why you did that trust in the first place. So no. So let's talk about revocable trust. Great, you could amend it, you could revoke it. The default in the EPTL, and in law school, I was so shocked because I always thought it should be the reverse, is that the trust is irrevocable, not revocable, if the trust is silent on whether it's revocable or irrevocable. So you don't say anything, it's irrevocable. I always would have thought that it would be revocable, but that's not the case. Again, you have to retitle assets to have it go into any trust. And we'll get to the testamentary trust soon. Obviously, it avoids probate, but it does other things. It avoids ancillary probate. Client comes into your office, oh yeah, we have a condo in Florida and we have a house here. And, Trust 101, if you did fall asleep, that's one of the first things that they said. I had Professor Wang in law school, St. John's, and he was amazing. I loved it. I loved the class. And it's one of the first things he said. So if the client has a home in another state, to avoid probate there, ancillary probate and probate here, it's a no-brainer. Let's do at least a revocable trust, maybe an irrevocable trust. Now, a revocable trust also avoids Medicaid recovery, but it will not protect assets for Medicaid eligibility purposes. So what do I mean? You could have an asset that's exempt now for Medicaid. You could keep your home because it's under a certain level. We're going to get into that. You could keep your home. So you could go on Medicaid and keep your home. Not always, but we're going to get to that. But then you die with the home in your name and Medicaid recovers against it. If it's in the revocable trust and it avoids probate, then it avoids Medicaid recovery. And that's huge, where Medicaid will recover to get all of the monies that they spent. That could be a huge number. A lot of nursing homes charge around $20,000 a month at this stage. It's incredible. Another advantage to a revocable trust, it provides for continuous management of assets after incapacity. Yeah, it's great to have the POA, but let's say assets are in this rev trust and the grantor is the trustee and the grantor / trustee becomes incapacitated. Then everything is under one roof. It's right there. And the contingent trustee steps in, the successor trustee steps in and starts managing. No asset has to be moved. Everything is within that trust. And look, the last bullet point, will is not private, but a trust is private, and that's another advantage. So contrast that to the irrevocable trust or revocable trust, depends on if you say tomato or tomato, it means the same thing. So can you revoke or amend that irrevocable trust? And the answer is, yeah, you can. You can. Look at EPTL 7-1.9 on the ways to revoke a trust. And basically it says, you need the consent of the grantor, you need the consent of the trustee or all of the trustees if there's more than one, and you need the consent of the beneficiaries. Case law says you also need consent of the contingent beneficiaries, and case law says that you cannot get consent from minor contingent beneficiaries because there's no one that could take away any of their potential rights. So many times an irrevocable trust is just that, irrevocable, because you can't get the consent of everyone. Now, there's a way around that. Now, the Medicaid trust is an irrevocable trust. And you remember I spoke about utilizing that power of appointment. And all of this seems to come together if you've been paying attention. So listen, what if we have this irrevocable trust and for whatever reason, it's only happened once or twice in my 40 years and we've done thousands and thousands and thousands of trusts, literally thousands and thousands of these Medicaid trusts. And if a client wants to revoke that irrevocable trust, if the grantor has capacity, well, the grantor could give that capacity. What if you have that POA that gives the agent the right to revoke a trust? Yes, then you get capacity again in another way, capacity of the agent on the power of attorney. So at least you got the grantor, the trustee. Now, when you're going to do this Medicaid trust, you're going to make sure that the trustee is someone you could trust and oftentimes control. So assuming the trustee or trustees will go along with the with revoking the trust. But what about all of these beneficiaries and minor contingent beneficiaries? And oh my God, what do we do? Well, we can utilize that power of appointment and get the assets out for a period of time to individuals that are over the age of 18 years of age, 18 years or older. And then they or he, don't forget, you could appoint to just one person, and that person could just be the trustee. In many cases, it's just the grantor and the trustee because you utilize that power of appointment. All of a sudden, you could revoke that irrevocable trust. So bear it in mind. The time that I spent on the power of attorney, very valuable because there's a connection with that power of attorney and the trust. And it's an extremely important one. You don't have to be old to become incapacitated. We've seen as attorneys some real horrifying situations. But typically, as a client ages, there's much greater of a chance that there might be an issue with incapacity. And you got to plan for that. Okay. Now, with the irrevocable trust, just the same, you got to retitle assets for it to be in the trust. Yes, it avoids probate, avoids ancillary probate, avoids Medicaid recovery, but with the Medicaid irrevocable asset protection trust, it can do all of that, but get assets out of that individual's name for Medicaid purposes if we draft the trust right. And we're going to get into that. And it also provides for continuous management of assets after incapacity, typically not of the grantor, but of the trustee, because we have either co-trustees or we have successor trustees, et cetera. And of course, we have privacy. Now, I've been talking about this Medicaid trust for a while, and now I'm going to get into this just for a minute or two, and we'll revisit this later on, but I do want to go into some other trusts just for a couple of minutes, get into some Medicaid, just give you a background on Medicaid so you see the importance of the trust, but the value of the trust it's so invaluable. The value is tremendous. Number one, it provides the client to live in the home for the rest of his life or her life or their lives. If there's, let's say, a brokerage account or a bank account in that trust, or the home that is rented later on, the grantor could get the income, can get the dividends, could get the net rental income from real estate. Pretty good. So the assets are out for Medicaid purposes, but you get to live there, you could get the income. You could direct the trustees to sell the property or exchange the property. You can get your 121 exclusion, that $250,000 husband and wife will get $500,000 capital gains tax exclusion if the trust sells the property. You can get the basis step up. So look it, the home is out of your name. The trust could sell it. You could downsize and have the trust buy a smaller condo, but you get your $250,000 exclusion. If you die with the trust, die with the home in the trust, then the estate will get the property and all of the property in the trust with a basis step up. You have that limited power of appointment, which gives the grantor more control and more independence. So that's great. Now, what about just transferring the home and or the vacation home subject to a life estate? Isn't that easier? Yeah, it's easier, but easy isn't always good. Sometimes it might be okay, but it's oftentimes not the best way to go. And the two biggest issues are as follows. First of all, everybody knows what a life estate is. You transfer the home to a third party, let's say the children, and the transferor retains a life estate in the deed saying that he or she has retained the right to the possession, use, and control of that property for his or her lifetime. So that's a life estate. So it's good. Yes, when you pass away under Section 2036 of the IRS code, you'll get a basis step up. That's good. But what happens so often in my practice, because we're dealing with older people, they say, oh, I'm going to die in the house. I'm not going to go anywhere. But then they get sick, or a child moves to California, or they just don't want to be there anymore. They're lonely. They want to be someplace else. So if the home is sold and it was transferred subject to a life estate, you have a huge issue for Medicaid. The value of the life estate is going to be deemed an asset. It's number one. And you have a capital gains tax issue because you only get that $250,000 exclusion on that small life estate portion. You just blew it tax-wise. And that's a huge, huge mistake. Now, sometimes we use a life estate. I'm going to get into that in a few minutes. And also with the trust, you get creditor protection. Transfer the home to the children subject to a life estate. And, something happens to a child or a creditor puts a lien on the home. Yeah, the creditor can't kick you out, but who wants that lien on the home? So you got to be careful. In that irrevocable trust, you could transfer brokerage accounts, bank accounts, life insurance if you want. There are trusts that involve the home for gift and estate tax purposes. Most of our clients do not fall within these huge numbers. The current federal unified credit or exemption is $12,060,000, but that's going to be halved right at January 1, 2026, or at the end of 2025. So it's going to be about $6 million. But, if you have a client with assets, remember, 40% is the tax rate. The gift and estate tax rate is 40%. What about New York State? New York State is great. We don't have a gift tax, but any gifts made within 3 years of death will be clawed back into the estate. And New York's level is about what the federal level would have been, if they didn't reduce it under the tax cut bill. So it is half, and that's 6.11 million in New York State. And the New York State tax rate ranges anywhere from around 3 to 16%. Just be careful about the cliff. If you go over if you go over 5% of the exclusion, then you fell totally over the cliff, and you will be taxed on everything by New York State, everything in your estate from virtually $1. Don't forget, if you're going to transfer assets or even pieces of real estate using the annual exclusion gift, you're going to fund a trust or with real property and I know it's small, 32,000 a couple, but it's something. Just remember that the annual exclusion gift went up by $1,000, 16,000 a person, 32,000 for a couple. So for our clients that do have lots of assets, you may want to think about a QPERT, Qualified Personal Residence Trust.
Hey, Ron, I'm just going to interrupt you for 1 second just to ask you for the course code.
Yes, the first code, and you'll tell me if there's a second one, is
just one for today.
Just one for today. Well, I wanted people to stay on this, so okay. I'm teasing. Is
they
spring.
Will.
It's spring, just like where we are now when you look out your window. Spring, SPRING.
Thank you.
Okay, everyone's got that, spring. Okay, now this QPERT is an irrevocable trust that holds your home or vacation home. You transfer the home into the trust and you retain the right to use the home for a period of years. And you get a discount for gift tax purposes based on how much you've retained, because you didn't give everything away. And the longer you decide to keep living in that home, the longer that retention of the right to stay in that home is, the greater the discount. But the pitfall of that is if you die before that term, well, that home just winds up in your taxable estate. If you outlive the term, then you made that gift, add a discount, and all of the appreciation in the future will be out of your estate. And it sounds wonderful, and it is, but just make sure you understand the drawback is that there will be a carryover basis. Okay. Another trust might be an irrevocable life insurance trust. You know, you have a client with a lot of money, or might be flirting close to the $6 million figure for New York State, because don't forget the feds will lower that figure in a couple of years anyway. You may want to transfer the ownership of the life insurance to an ILIT, an irrevocable life insurance trust. And you may want to use testamentary trusts. Now, the reason I'm bringing up testamentary trusts before I get into some of the Medicaid points is that I want you to be very careful. If there's a husband and wife that you consult, and this is an issue, I would say many elder law attorneys themselves make a mistake with, but it's a huge mistake. So what happens sometimes, a husband and wife come into your office, husband has Alzheimer's, wife says, I want to leave assets for my husband. You know, and I say, well, that's great, but we're going to get him on Medicaid. You know, she said, I don't care. I don't have any children. I still want to give to him. That's okay. But the only way to do it without an adverse Medicaid situation would be to do it in a testamentary trust, not a living trust. Make sure you don't make that mistake. Okay, be careful about the right of election. You might say, well, how does that fit into Medicaid? Well, you might waive the right of election with a waiver of the right of election, or with a prenup or a postnup, and that's fine for estate planning, but it's not fine for Medicaid. Medicaid is clear based on an awful case from years ago. Medicaid said, we won't accept any waiver of that right of election. And if the client doesn't assert the right of election, we're going to force the client to assert the right of election. So look at the example that I have. Let's say the well spouse dies with $300,000 and didn't do any planning. You know, we have to do planning for the individual who goes on Medicaid and for the spouse. And once that individual is on Medicaid, we have to do post-eligibility planning. But if that spouse didn't do any planning and say, we don't need it, well, you do, because this is what happens with the $300,000. even if there was a waiver of the right of election, Medicaid would assert that right of election and force the assertion of that right of election, and have the individual, or force, you can't force someone to do anything, but we'll say that that 1/3 amount, or 50,000, whichever is greater under the EPTL, that's going to be an asset in the Medicaid recipient's hands, and that will throw the individual off Medicaid. If that does happen, we would do a technique called the promissory note rule of halves. Always remember that Medicaid is mandated to recover from the probate or administered estate of a Medicaid recipient. So we want to avoid that. Again, we spoke about the living trust. In just a couple of minutes, I'm only going to go for about another 8 minutes. But the only way for most people, unless they're really rich or they have amazing long-term care insurance, if you have millions or you have long-term care insurance with like a $650 benefit a month, crazy people like me, that's what I have because I've seen horror stories, but nobody has that, or hardly anybody has that. Then you got to look to the Medicaid program. And anybody who's 60, 65 or older got to do planning for long-term care. And right now, there's no look back for Medicaid home care. There's a 5-year look back for Medicaid nursing home care. So let's say that again. Right now, there's no look back for Medicaid home care. For Medicaid nursing home care, there's a 5-year look back. What's coming down the pike is that starting July 1, that's what DOH says, the Department of Health, there will be a 30-month look back for Medicaid home care for applications submitted on or after July 1. This has been postponed several times. It's likely to be July 1 now, and that's what DOH says. Now, to be on Medicaid, you can only have assets of $16,800. You might have heard rumors that in the governor's budget, she's eliminating the asset test. Well, that was only there. The intent was only there for Medicaid insurance, but it wasn't written very well, and it can be interpreted either way. So I am assuming, because I only budgeted $5 million for it, and it probably would cost the state $1 billion, something like that. I'm making up a number, but the system would be, just watered down so that nobody would get any kind of care, if that really happened. But if it really does happen, keep your ears to the ground. They're talking about it today, and I spoke to 5 legislators today trying to make sure that Medicaid is around for clients that need it. So I'm working hard on it. Anyway, the individual could keep $16,800, the spouse up to $137,400. That spouse could also keep income of $3,435 a month. And if it's a nursing home situation, the sick spouse on a nursing home can keep only a $50 personal needs allowance, but at home can keep $954 a month. Nobody could live at home on $954 a month. So we have a pooled income trust that we could use where the surplus income, the income that's over the $954 plus health insurance premiums, could go into this trust to be used for pay rent, mortgages, maintenance charges, Con Ed, etc., National Grid, whatever it is. The spouse can sign the spousal refusal. I'm sure you heard about that. That is still around. So right now we have, and I call it an unprecedented planning opportunity, and the window will shut. So if we submit a Medicaid home care application now, until June 30th, well, there's no look back. If our client transfers $500,000, no look back. If our client transfers $750,000, no look back. But if that transfer happens on or after July 1, except if, they might postpone it again, who knows? But DOH says it's going to be July 1 at this point. But if that's the case, then the next day, July 1, is going to be a 30-month look back for home care and a 5-year look back for nursing home care. How that look back works, let's say nursing home care. Medicaid will say from the time you're in a nursing home, you get your assets down to the Medicaid level and you apply for benefits, Medicaid will look back 5 years. Don't forget, for home care, it's going to be only 2.5 years. So in a nursing home situation, they look back 5 years, and they're going to look to see what assets the Medicaid applicant and the spouse have transferred. And let's say there's an application in Westchester, and you see it's $13,399. Let me round that off to $13,000 so I could do the math quickly and easily. So that applicant, applies for Medicaid nursing home care. His assets are under $16,800. The spouse has her own assets, and Medicaid looks back 5 years and they see $13,000 was gifted. They say, okay, you could go on Medicaid, but we're going to penalize you and make you wait 1 month for Medicaid eligibility purposes. So you got to pay on your own for 1 month, and then we'll pay. Why? Because you have the ability to pay for 1 month of care, whether in a nursing home or at home. These are the figures that Medicaid assesses that 1 month of care for, and that's $13,000. On Long Island, it's $14,000. Medicaid looks back and they see $26,000 that was gifted. Well, you just gave away 2 months of care, so Medicaid won't cover for 2 months. What if it's $130,000, or in Long Island, $140,000? They'll make you wait 10 months. What if you transfer that home into the trust? You take the value of that home divided by, if you're in Westchester, $13,399. Now, there are some exempt transfers that Medicaid says, we see that you transferred the home, but the home is transferred to the spouse. That's okay. They won't penalize you, or any assets to the spouse. The home or any assets to a blind or disabled child. And then there's special rules regarding the home. If that home was transferred to a sibling who lived there and has an equity interest for only 1 year, so you take 5 years and bring it down to 1 year, that's exempt. And the next one we use a couple of times a week. The home is transferred to an adult child who's a caregiver and resided in the home for 2 years, and that's another exempt transfer. And this is my last part, although I have another 20 slides to go, but you have the slides, feel free to go through it, and I'm here to answer questions. The current home equity limitation is $955,000 for Medicaid. What does that mean? That means that if an individual who doesn't have a spouse is applying for Medicaid benefits and wants to keep the home in his or her name, if the equity in that home is greater than $955,000, he's not eligible for Medicaid because he has too much money. That figure just went up about $50,000 a couple of months ago. The exception to this, and last bullet point, if there's a spouse, minor, blind, or disabled child living in the home. So I'm going to stop here, gave you some examples. I spoke about a lot of these. Medicaid home care is getting much more complicated later on, starting July 1. So you have some of that information if you want. And I did talk about in the later slides about using a trust protector. So Diana, thank you so much for having me. And I'm happy to answer Any questions?
Sure. I do have quite a few questions, but we'll get to as many as we can in the next 5 or 10 minutes.
Sure, I'd be happy to.
In a POA, if there are 2 or more agents, can one agent actually delegate authority to the other agent, notwithstanding the language in the POA? And can that also happen with regards to a trust as well?
Well, that's a very good question. So you're saying if there's a POA that says, we want, the principal says, we want both of you to act together. Can one agent delegate to the other? I don't think so, because it's right there. It's my guess. I'm not 100% sure, but I really don't think so. Okay. You can typically delegate to third parties under the statutory language, but I don't think when the principal specifically says no. But if one agent dies and you have 2 that have to act together and there's only one left, that individual can act.
Okay. Is an EIN needed on an irrevocable trust?
It depends on that irrevocable trust. Many do and some do not. If you have a grantor trust and that grantor is keeping the income, you typically don't need an EIN number on that grantor trust.
Okay. Is there a definition?
You likely need it on death. So we typically get it anyway, but you don't need to in that circumstance.
Is there a definition of a bank for power of attorney purposes? Today, many mortgages are given by companies who may not be banks. Am I correct that these private mortgage companies do not have to accept a POA?
That's a very good question. I would say look at the GOL. There are, definitions. There should be a definition of a bank. If I recall, I'm not sure. I don't know if it covers a mortgage bank. I really don't. But don't forget, even if it doesn't cover a mortgage bank, that mortgage bank is a third party. So I think they should still need to accept that power of attorney.
With respect to a trust where title to the grantor's residence was transferred to the trustee, are there any filings, tax or other, that the trustee needs to file, assuming that the grantor continues to pay the property taxes? Okay.
If it's a trust that's a completed gift for IRS purposes, in other words, it's out of your estate, then yes. But if it's a trust where when it's a trust that's not a completed gift, that's going to wind up in your taxable estate, no.
Does the existence of a revocable trust need to be disclosed in a matrimonial action?
Yes. That would be too easy of a way out. But I'm not a matrimonial attorney. Disclaimer, check with your matrimonial attorney. But yes, it's an asset that you totally control.
Okay. That might be long to answer. I'm going to okay. I'm just going through the questions. I'll get to 1 or 2 more and then how do you handle the mortgage and rental income when a client lives in a multifamily home and rents out the other unit? Does the trust pay the mortgage, taxes, and expenses before paying the net income to the grantor?
Okay, it literally depends on how we draft the trust. If you say that the trustee is to pay the expenses on the home, then the trustee will pay the expenses, but you can set it up so that the grantor pays the expenses on the home.
Okay, I'll get to 2 more questions and then we will wrap it up in an interest of staying on schedule. If someone has not prepared a Medicaid trust and are having to go into a nursing home, what, if anything, can be done to protect their assets? Can the family prepay funeral expenses? Anything else you would suggest?
Yes, the family can prepay funeral expenses, not only for the Medicaid applicant, but also for the spouse, also for the children, also for the spouses of their children, and I even believe brothers and sisters. So there could be a lot of burial and funerals that can be prepaid. So that number could easily exceed $100,000 for most families. But what would we do after that? See if there are any exempt assets. I changed the law on retirement accounts in Medicaid about 15 years ago. That's an exempt asset. But when you have assets that are not exempt, by the way, retirement accounts are only exempt if they're in payout status. That's how it had to be when I argued that case. But what do you do with the other assets? Because you're not going to transfer a retirement account into a trust. We could do that promissory note rule of half, where if the individual has no spouse, all alone, applying for Medicaid nursing home care and has about $400,000 over the Medicaid limit, through that technique, we could preserve about $200,000 or about half of the assets at the very last minute.
Okay, we'll get to one last question. I always have clients ask me the best way to transfer their home to their adult children. What is the best way?
Well, as I said, typically the best way is into a trust. And depending on the circumstances, if the client, has $2 million, you're likely not going to do a Medicaid trust. Or it could be in the Medicaid trust. It could just be in a revocable trust just to avoid probate and have continuity of management. It depends on the circumstances, but it certainly makes things a lot easier later on if there aren't other assets to probate.
Okay, great. And on that note, it's 2:05, so we're going to end. It's always wonderful to see you and have you speak, Ron, and we appreciate everyone for attending.
Thanks. Thank you so much, Diana. Thank you. Additional title. Take care.
Take care.